Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Arianna Mendez walks through the Google Play Developer Distribution Agreement. So let's tear it down. Arianna, how are you today?
Hi, Mike. Thanks for the invite.
Yeah, absolutely. We're going to get nerdy today, as we often do on this show, because we're talking about video games. We've got like this Venn nerd diagram of like video games and contracts and all the cool kids. So what we're going to talk about is this document. Let me share it real quick, Arianna. This is a Google Play Developer Distribution Agreement. Before we dig into it, Arianna, what is this thing? When are we going to see something like this?
Okay, so every time you try to sell something on either the Google Marketplace or an Apple Marketplace, you're going to get something like this Google Play Developer Agreement. It's quite standard in the industry. Google and Apple are kind of the head honchos. They know what they're doing in this area. So this is run-of-the-mill when you're trying to sell something on one of these marketplaces.
Yeah, and we'll get into that reality. Before we do, Arianna, tell me about your background. What brings you to documents like this? What's your practice like?
Sure. I run the law firm Arianna Mendez out of Miami, Florida. We do civil litigation, business, real estate, and estate planning work down here. And a big hello to everybody that up north is dealing with the cold weather. We're sunny down here and quite nice and toasty.
We had very confusing snow today. Like it started to snow last night, apparently, and then it was like, it's too cold out here. We're not going to do this. And so it just sort of stopped. Very confused here. Okay, so here's what we're going to do. As you deal with a lot of litigation things, business litigation things, and so that's what we wanted to bring you in for, was that perspective. And there's litigation going on about this particular document. So before we dig into the nitty-gritty of this document, can you just give us some background on what's going on with this case? People have probably heard about this case between the Fortnite people and Google. Tell us about the case. What's the state of things right now?
Oh, Mike, the tea is hot with this one. Epic Games, the developers of Fortnite, which is a really popular, battle royale video game out there, free access, very popular with video gamers. So they sued Google last year because they're alleging that Google is a monopoly and that their practices are not competitive. It's not an open marketplace. They're that bad word, monopoly. And ironically, Epic Games violated the Google Play Developer Distribution Agreement on purpose so they could start litigation against Google and Apple. And basically right now, the Apple case last year kind of headed towards resolution. The judge said, hey, Apple is not a monopoly, but now Epic Games is appealing. The Google suit is going to trial later this month. So it's just a lot going on. But there's a chance to make interesting case law if Epic wins, and it could change the way we buy apps on both of these two platforms forever.
Yeah, there's a dynamic with this situation where there's inside the contract and there's outside the contract, which is an interesting thing as we sort of address the questions inside the contract. When is the contract sort of creating problems that we can avoid? Mm-hmm. And when is it like there was nothing you were going to be able to do here? This fight was going to happen anyway, and Google is really using the contract to try to, do some social engineering, basically. So let's talk about that with that distinction in mind. And what we're going to do is go through the document as we do. I'm going to start with 2.1 under Section 2, accepting this agreement. It says, this agreement forms a legally binding contract between you and Google in relation to your use of Google Play to distribute products. What are you seeing in this section that you like? What don't you like as a drafting exercise? And maybe how it led to the fight that we're in now?
Sure. From a drafting perspective, this is a great paragraph. It includes everything you want in there. It can be said it's a bit boilerplate, but it does the job quite nicely. But at the end of the day, this is what starts the relationship, starts the problem for Google, creating that relationship with Epic Games. And Epic has other things in mind. So even though they agreed that they were entering into this contract with Google and all the terms we're going to analyze later on, it didn't really matter. But hey, it's a good paragraph.
Yeah, it's well written and actually gets us to 3. Speaking of that relationship, it defines what the relationship is. The commercial relationship, pricing, payments, and taxes section. Under 3.1, it says, you hereby appoint Google as your agent or marketplace service provider as outlined here to make your products available in Google Play. What about that relationship?
So again, this goes to the heart of the lawsuits that right now are happening because literally this is over the marketplace, the Google Play marketplace, and technically Epic Games did sign up for all the terms outlined here, and that Google would be their agent in that marketplace. It meant that Google could distribute and give users access to the products exclusively because they were on the marketplace. So this is at the heart of the litigation. It's good, it's doable. Yes, it's boilerplate, but it works. But again, it doesn't matter in this particular case what we're dealing with, the bigger issue here.
Yeah, it's interesting where you have this agent language and you have this idea of like somebody going out and acting for you or whatever, but this is a distant relationship. I mean, most of the time, Google is not interacting really with the people who are creating things in here. So it's interesting that you have that, sort of the old school ideas of agency, but not really. And if you look at 3.4, I mean, it digs into the pricing piece of that. Acting as your agent and with you acting as principal, Google is a merchant of record. They talk about defining the service fees, how much the payment is. What do you think about 3.4 as it fleshes out that agency relationship?
It's pretty good. If you were to go into the service fee, it's that 30% that is standard in the industry for every time that you are trying to sell something on these marketplace. The marketplace gets a cut, and it used to be called the Apple tax because it was Apple the first one that started using it. But the industry has changed so much that a lot of people talk about the service fee and say, "Hey, is this really a good fit for today's marketplace on app stores?" So again, a good paragraph contract wise, but this is really going into that 30% that Epic Games really wants to stop Google from getting. And the argument is, hey, you're getting the service fee, but it's because you're a monopoly, not because it's actually fair.
Yeah, and I think getting to the meat that's really driving this lawsuit and this confusion, let's jump down to 4.5. This is under use of Google Play by you. 4.5 says you may not use Google Play to distribute or make available any product that has a purpose that facilitates the distribution of software applications and games for use on Android devices outside of Google Play. Here's the breaking. Tell me about 4.5 and how Epic Games dealt with this section.
So this is exactly what Epic Games decided they were going to do the opposite of. So they were going to push out a patch, quote unquote, a patch that Google was not able to detect before it went live, and it gave users the option of buying add-ons directly to Epic Games from Epic Games and bypassing that 30% tax, if you will, that Google Marketplace would be putting on the transaction. So Epic Games knew what they were doing. They were offering a cheaper way for users to get the add-ons, and they didn't care, even though they signed a contract that says they're very black and white. You can't do this.
Yeah, and it's interesting, just as an aside, one of my annoyances in life is when my iPhone decides to go on Amazon and give me the Kindle version of a book versus jumping over to the Amazon app and giving me the hardback cover, right? Because if I use the Amazon app, if I use an app on iPhone for a digital delivery device, purchase like a Kindle book, well, then Apple gets their 30%. But if I go buy a physical thing on Amazon's app, it's not true. And the way to go around that is I have to go on my Safari browser on my phone and buy I don't know if you guys knew this, but this drives me crazy. I have to go to the Safari app on my phone, just the internet, and buy a Kindle thing there. So I guess maybe I'm wondering, is this a leverage thing? I know this is a bit into the big question. How come Amazon can get away with that kind of thing? Is it just that they're so big and Epic is relatively small compared to Google? Is it just a leverage question that Amazon's avoiding that fee and being okay?
Well, for Amazon, it's a little bit different because Google is offering you access to millions and millions, potentially billions of customers. So their argument is we're maintaining this very pristine environment for you to go there and do commerce. So this 30% tax, if you will, is for us to maintain that pristine environment, right? And by the way, you can buy games from somewhere else. So it's not like we're the only game in town. Amazon is a little bit different. They have other models when they do business, but for Google, if they're to maintain the app store, maintain the back behind the scenes stuff, that's how they justify that 30% fee. For Epic Games, it doesn't make sense in their argument. It says, hey, that should not be the case because you have a very wide scope of customers you have access to, and you're the gatekeeper, so we can't really get to them any other way. That's why you're a monopoly.
Yeah, and continuing with that, in section 4.6, it says you agree to use Google Play only for the purposes that are permitted by this agreement and the relevant law, including any laws regarding the export of data or software. What do you think about section 4.6 and this use of data conversation?
Again, this covers precisely what Epic Games did. They pushed out a patch that got consumer information, in this case, credit card information, payment information, and it went directly to them bypassing Google. So this was drafted potentially for something like this in mind to prevent something like this to happen. But Epic was making a bit about something bigger than just this contract. At this point, this is just a piece of paper for Epic.
Well, I mean, for me, this prompts, as we think big picture, two sort of categories of questions. One is what this does socially, right? And that's what's behind every antitrust conversation. It's public policy questions. And then secondarily, what it does for the drafter making decisions. So let's start with the first one. Thinking about the social implications of this, a marketplace is there in part because this small business doesn't have the resources. They know that Google has more than them, and they're okay with that. Google will give them a place to develop a safe coding environment. That relative difference in size is an asset at that time. But at some point, Epic starts to win, right? Epic gets big, they become their own brand, and they're not able to get all the returns on that brand that they built up through Overwatch because Google has it. So socially, what do you think about this sort of, should there be a point at which it's like, okay, now you're cool enough, your brand can stand on its own, let's give you your own 2 feet. Like, what's the function of marketplaces in sort of an antitrust environment where we know they're monopolies? That's why they're the marketplace.
Well, there's very specific factors that need to be considered in order for you to qualify as a monopoly under the law. And the most important question is there alternative ways for you to get that same product or service without the company in question? Arguably, in a gaming environment, there's a lot of options. You can go on stream, you can try Xbox, PlayStation. There's a lot of different ways that you can get that product. What Google and Apple are both offering is access to the mobile user. And arguably, they do dominate those two in that marketplace. So that's a bigger question for the courts to analyze. Is two enough? Is that enough competition, or are we talking about a dual monopoly of this marketplace? Now, on Epic's point, they were ready for a more of a social conversation. I honestly had a video ready making fun of Apple, and I invite your viewers to look this up. It's hilarious. You have an evil-looking Apple-like logo, basically with Nazi-inspired imagery, trying to make this case that Epic is standing up for the small guy in gaming. That developer out there that's trying to make wind. And we're talking about a multi-million-dollar company when it comes to Epic. So we're not talking about somebody that fits that description, but they're making it about that because the potential for profits for them down the road, if this changes, is astronomical. So this is not so much about the user. It's a fight between tech giants.
It's an interesting thing as an aside, especially Apple, or especially Google, but even Apple shifted at some point from being a hardware company to being an audience company. The idea, their whole profit source is the access to people. And so when Epic does that, they have to go to Google because Google has the hardware connection, right, to the human being. But really, it's not a hardware conversation. It's about the connection to the audience. Epic, by doing this, is attacking exactly how Google makes money, and now Apple too. Post iTunes, it wasn't about the iPod, it was about iTunes. It was about the relationship for selling software. So they're going right after these big companies' sources of profit. As far as drafting goes, part of me, it's going to be very rare that the viewer of this show is going to be writing an agreement like this for a giant like Google. So thinking about that specific environment. But you see a lot of software companies now, platform is the new black, right? As they say, the idea is that you want to be the marketplace, you want to be the central point. So there are going to be lawyers who are watching this, who are trying to draft in a way that gives somebody those marketplace or those platform kind of advantages. What do you see in this experience that can help that lawyer that's drafting this to say, trouble's going to come if we get too big, but we're not all going to become Google. Here's how I can learn from this Google experience to draft better the kinds of agreements that I'm writing for my size company.
So I think any drafting changes have to come from the stakeholders, right? So the stakeholders have to make policy changes in order for the drafting to reflect that. For example, Apple is already making changes. They're allowing app developers to contact users directly and maybe offer cheaper alternatives to their marketplace to purchase these add-ons. So as those changes happen on the corporate level and the C-suite gets their head together and decides these are the next steps, lawyers like me can look at agreements like this and start fleshing out provisions that included language there that protects the company from violations of that new policy in the future.
Well, it's an exciting and dramatic and ongoing problem as we talk about it. This is like the one lawsuit that my kids will have a conversation with me about. This is the one time that they're like, okay, I can talk to dad now, because otherwise I'm just useless to them. But this is an interesting one for people who want to learn more about your work, the litigation of these kinds of cases, how to draft better to avoid litigation later. What's the best way to connect with you, Arianna?
Definitely on my Instagram at @amendezlaw. We are updating there constantly, and I have videos like this talking about different topics. So it's a lot of fun, both in English and Spanish.
Awesome. Well, we'll include a link to that as well as this document and a couple of articles about the story and what's going on with the cases over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email us. We're at community@lawinsider.com. I'd love to hang out with you. And until next time, we will hang out and learn more. And I'm going to go play a video game. Thanks, Arianna. Y'all have a good day.
Bye, Mike. Take care.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.